Judgment in the appeal, Hastings Borough Council and Manolete Partners Plc.
Lord Carnworth will hand down the judgment of the court.
In June 2006, the Hastings Borough Council exercised its emergency powers under Section 78 of the Building Act 1984 to restrict public access to Hastings Pier because of its then dangerous structural condition. A company called Stylus operated a bingo hall and amusement arcade on the pier. This appeal concerns a claim to compensation for loss to its business caused by the closure. It is brought by the present respondent as Stylus's assignee. Section 106 of the Building Act gives a right to compensation for loss caused by such action, but only in relation to, quote, a matter as to which the claimant has not himself been in default. The council argued that Stylus had been in default. They relied in particular on its statutory responsibilities for the safety of its clients and employees, which they said had been put at risk by the state of the pier. This defence was rejected by the courts below, principally on the grounds that default under the section was limited to default under the Building Act itself. The Supreme Court unanimously dismisses the Council's appeal for the reasons given in my judgment, with which the other justices agree. The relevant words of the section raise two questions. First, what was the matter in relation to which the authority exercised its powers? And secondly, was that a matter as to which the claimant had been in default? The matter which led the Council to take emergency action, as identified in a letter sent to the tenants at the time, was the state of the pier, combined with the fear of possible collapse from crowd loading during events planned for later in the month in other parts of the pier. Whatever Stylus's legal responsibilities to its clients and employees, it was not any default in that respect which led to the Council's recourse to Section 78. It is not therefore precluded from claiming compensation. The Court does not, however, agree with the courts below that default is confined to default under the Building Act itself. Such a limitation is supported neither by the statutory language nor by the authorities under previous statutes in similar terms. Finally, the Court emphasises that its judgment is not intended to limit the issues which can be taken into account by the arbitrator in assessing the level of compensation. The arbitrator may take account of any matters including the state of the pier and Stylus's statutory and common law responsibilities, insofar as they might have affected the continuation of business quite apart from the effects of the emergency action.
We will adjourn.